In this video, we take a look at the latest XRP news. Will XRP be able to fly to the moon? Write answers in the comments. The current triumph is unquestionably a last nail in the coffin. The issue is whether the SEC will abandon the complaint or seek a settlement with Ripple. The court's decision to deny the SEC's appeal confirms an earlier determination that secondary XRP sales are not securities transactions. This demonstrates that Ripple's conduct in selling XRP tokens are not in violation of securities legislation. The judgment of Judge Annalisa Torres dealt a blow to the SEC's legal approach and exposed several significant flaws in its reasoning. The SEC's approach was predicated on the notion that some XRP sales might lead to investors anticipating rewards based on Ripple's efforts. However, the court deemed this argument to be devoid of relevant evidence, confirming the prior decision. Ripple's CAO, Brad Garlinghouse, didn't miss the chance to remark on this recent event in his ex-post after Deaton. He humorously observed that the C, in its pursuit of applying the Howey test in the case, eventually lost. He mocks the SEC's own creation of this criteria, based on which they were slammed in court. They seem to want an exceptional lawyer to comprehend the significance of their own made-up securities legislation. Looking forward, the SEC is now in a position where it must await additional findings in the wider Ripple action before considering any appeal. The next central hearing is scheduled on April 23, 2024. However, both parties must file pretrial materials by December 4, 2023. According to Jeremy Hogan, the matter will either go to trial or be dropped in April. Furthermore, this judgment enhances the judge's prior ruling, making it more difficult for the SEC to prevail in any prospective appeal. As the current tide is moving towards Ripple and Coinbase, the SEC may be in a stronger position if they act in their best interest to introduce clear crypto legislation. The SEC is facing a critical decision. In a recent discovery, digital asset researcher Anders revealed why the U.S. Securities and Exchange Commission, SEC, chose to pursue Ripple and XRP. The Securities and Exchange Commission's allegations against Ripple in December 2020, citing the sale of XRP as an unregistered securities offering, sparked discussion in the crypto world, especially among XRP fans. Deaton presented a range of thought, provoking questions in his thread about the SEC's special targeting of XRP. He questioned why the SEC would choose a more difficult case, drawing parallels to the early sales of ETH when the Ethereum team launched a simple initial coin offering ICO. Anders points out that the SEC's determination to target XRP is motivated by Ripple's creative use of the digital asset in cross-border settlements. Ripple's use of XRP, according to Anders, undermines the conventional nostro-vostro accounts and banking paradigm, which has long been a substantial income source for many big banks. According to the study, this disruption threatens to expose established financial institutions' lack of innovation. It is critical to understand that Ripple Labs' primary goal is to revolutionize blockchain payments, with XRP playing a key role. Ripple removes middlemen in cross-border settlements, reducing delays and excessive transaction fees. Notably, Replex reported that the XALS 39 clawbacks functionality, which is scheduled to launch on the XRP, is now up for vote. Ripple to David Schwartz got forward to give his opinions after the news was met with skepticism from community members. Schwartz has attempted to ease concerns about this new function. He began by explaining that the clawback functionality would allow token issuers to recover a particular number of issued tokens from existing holders. He said that he was originally opposed to the functionality since the XRP already had the freeze feature, which is identical to clawback. However, he said that the obvious contrast between clawback and the frozen function caused him to reconsider. Schwartz emphasized in his comparison that the clawback function would find a main use case in legal disputes. He feels that the opportunity to recoup some cash in the event of a disagreement relieves the token issuer of the legal responsibility. This protection, according to Schwartz, is crucial for complying with court orders. He feels that auditing protocols on the XRP will be challenging with the existing model without the clawback capability. As contrast to freeze, which is a more nuclear option, the Ripple key to define the capability as a tool that enables for surgical strikes to preserve the XRP intact. Overall, Schwartz said that this new capability is presently available in blockchains that house stablecoins. He pointed out that if the proposal fails to pass, token issuers would have to go to the trouble of activating the functionality in some manner. Other major players in the XRP ecosystem, including as Rathoff Niemann, have also worked to debunk falsehoods concerning the clawback function. According to him, there is no hidden adjustment in the XRP ledger ecosystem. With the issues addressed, the clawback functionality will be implemented if 80 of existing validators vote in favor of the proposal. For the proposal to fly, the minimum threshold must also be maintained for at least 2 weeks. The XRP has undergone a considerable revision in recent months, with a number of changes suggested. The team behind the XUM wallet recommended a revamp of the XRP infrastructure to incentivize participation via incentives, as previously reported by the crypto basic. Spend the Bits, a payment protocol on the XRP, won the top position in the Ripple CBDC Innovate Award, a display of the ledger's exemplary work, recognizing the efforts of the core developers internationally. The community that supports the blockchain startup Ripple has opted to celebrate the earlier, partial triumph this weekend, even while the rest of the cryptocurrency world is waiting for the formal conclusion of the judicial fight that has been going on between Ripple and the United States Securities and Exchange Commission for quite some time. Ripple CEO Brad Garlinghouse, Stu David Schwartz, legal experts Jeremy Hogan and John E. Deaton, and a great number of other people were present at the proper party, which took place on September 30. This event brought together not only XRP and Ripple enthusiasts, but also people who were closely involved with the ecosystem and the lawsuit itself. Right before the party, Garlinghouse shared a few images with the audience that was gathered outside the venue and said that this event was a celebration of collective accomplishment and a reminder to the SEC that court decisions matter and that progress is worth fighting for. He went on to say that this event was a celebration of collective achievement and a reminder to the SEC that court decisions matter and that progress is worth fighting for. When giving his speech during the event, which also featured a star performance by Lenny Kravitz, Garlinghouse said that it was this village that beat the bully, referring to the XRP and Ripple community and its stand against the regulator, in a video that was shared in an X post by CryptoLaw on September 30. He said this in a video that was shared in an X post by CryptoLaw. Earlier, CryptoLaw published an article produced by Frank Francone, a policy others at the Centennial Institute and a California attorney. In the piece, Francone stated that the SEC's central argument failed almost completely under judicial scrutiny, which caused harm to a lot of innocent people in the process, and not just the defendants in the case. CryptoLaw also stated that the SEC's actions had harmed a lot of innocent people in the process. As the creator of CryptoLaw, John E. Deaton, also pointed out in a comment he made on Francone's arguments in the article headlined, "The SEC is not the king. 75x investors, users, developers, and small businesses have been screaming the above for 3 years," which was published in an X post on September 28. In the meanwhile, a lawyer named Bill Morgan brought attention to the disparities in the SEC's arbitrary enforcement by noting that Mark Berger was pro-crypto when it came to Ethereum, ETH, and its co-founder Joseph Lubin, but while he was deputy director of the Division of Enforcement, he sued Ripple. More recently, on October 1, Jeremy Hogan emphasized that back in the early 1980s, the SEC had attempted to pull the same thing as with XRP, but with gold, when inflation was high, and gold was the investment, and that the courts had put a stop to it at the time.